am your moderator for this final panel of the afternoon. My name is Ruetschlin, and I'm an assistant professor of economics here at the University of Utah. I'm actually a labor economist who is just wading into the realm of antitrust research, and as a result, I'm particularly excited to hear the speakers on this panel today. We have an impressive cross-disciplinary representation in the room, including the audience and the panelists. But if you're a person who hasn't had the opportunity to traverse the boundary between labor economics and antitrust, the intuition is simple. If it's the case that firms have an incentive to use their market power to enhance profits by raising prices in the product market, where they're the seller, then they have a parallel incentive to enhance their profits by lowering prices in the labor market or other factor markets where they're the buyer. Recent empirical trends, as mentioned before, have turned renewed attention to these interrelationships between buyers and sellers and the harms we experience parallelly as consumers and as workers. The evidence includes measures of growing firm concentration concurrently with declining worker power and wage stagnation. And although there's clear policy on outright illegal collusion, such as no poaching agreements in the labor market, our panelists today are going to identify a number of challenges that remain for policymakers to address, including examinations of structural conditions in the labor market and innovations in the corporate structure that empower the command-based economy operating within the firm to bleed past its boundaries and limit worker bargaining power both inside and outside the firm. Robust competition in the labor market is essential for worker bargaining power, which is essential for economic growth to be broadly shared. And these benefits are only possible in a competitive market that encourages innovations that drive material improvements in our standard of living rather than innovations that avoid the legal protections of workers. Where we miss opportunities for antitrust remedies in the labor market, we miss opportunities for improved living standards for all. And this implication makes our panelists' work today of crucial importance for all in society, whether or not you transact in the particular market under discussion. So thank you, panelists. And with that, I will introduce you to the people doing this important work. First on our panel is Ted Tatos. He's an adjunct professor at the University of Utah and a consultant with Econ 1 Research. He's also the associate economics editor of the Antitrust Bulletin and has published articles on various economic, legal, and statistical topics. He's a graduate of Duke University and the University of Utah, and he has over 23 years of experience in litigation and non-litigation consulting with a focus in antitrust, intellectual property, labor, and commercial damages. Elinor Hoffmann is Deputy Chief of the New York Attorney General's Antitrust Bureau and Special Counsel to the Economic Justice Division. She focuses on antitrust issues under state and federal laws in diverse markets. She's also an adjunct professor of law at Brooklyn Law School, where she teaches courses in antitrust and antitrust issues in healthcare, and serves on the advisory board of the Health Law Fellowship Program. Prior to joining the Office of the Attorney General, she was a partner in the firm of Coder Brothers, LLP, for 16 years. Brian Callaci received his PhD in economics from the University of Amherst, UMass Amherst, University of Massachusetts, Amherst, in 2019. He's currently a postdoctoral scholar at the Data and Society Research Institute. His research focuses on the changing legal and economic boundaries of the firm under vertical disintegration structures, such as franchising, and the implications for labor and antitrust law and policy. Our last panelist is Sanjukta Paul, who's an assistant professor of law at Wayne State University. Her current research and writing involves the intersection of antitrust law and labor policy. She's at work on a book tentatively entitled Solidarity in the Shadow of Antitrust, Labor and the Legal Idea of Competition, which will be published by Cambridge University Press. She previously served as David J. Epstein Fellow in Public Interest Law and Policy at UCA Law School. There she designed and taught the Workers' Rights Litigation Clinic, which represented low-wage workers in wage theft claims, and in a complex class action alongside legal nonprofit organizations. Prior to this, she was a public interest lawyer in Los Angeles for several years, focusing on employment, civil rights, and labor matters. Paul clerked for the Honorable Alfred T. Goodwin of the Ninth Circuit Court of Appeals and is a graduate of Yale Law School, where she was a Coker Fellow. Our discussants are Sandeep Vaheesan, who we met this morning on the panel first thing, and Hal Singer, who is an expert in antitrust and regulation. He's researched, published, and testified on competition-related issues in a wide variety of industries, including media, pharmaceuticals, sports, and finance. He has extensive experience providing expert economic and policy advice to regulatory agencies in the US and Canada, as well as before congressional committees. He has a PhD in economics from Johns Hopkins University and is a senior fellow at the George Washington Institute of Public Policy and an adjunct professor at Georgetown University McDonough School of Business. Thank you all for being here today, and we look forward to your presentations.
Okay, so my presentation is going to be a little bit of a change from the earlier, very theory-driven discussion, and I'm going to focus on particularly two cases, the NCAA grant and aid cap antitrust litigation, which is ongoing right now. It's currently before the Ninth Circuit, and the Ohio versus American Express case. And on first glance, you might think these cases have nothing to do with each other. They're in entirely different markets. As it turns out, they have a great deal to do with each other, and I'll explain why. The issues facing the NCAA right now, I think, well, maybe you've heard, are wide-ranging. Right now, the NCAA is facing various state statutes regarding name, image, and likeness, particularly from California, now Florida, South Carolina, New York, as well as a nationwide proposed litigation from Mark Walker of North Carolina. And I'd like to point out, which is somewhat heartening for me, that in this era of very brutal partisanship, I would say, it's very somewhat heartening to see that the litigation or the legislation has received bipartisan support from legislators in various states. So I'll start off on the paper. This is it's based on a paper I wrote that was published earlier this year in the Harvard Journal of Sports and Entertainment Law, and it discusses essentially how the Ohio versus American Express case played a role in the NCAA grant and aid litigation. So let me give you just a little bit of a background on that case. It dealt with anti-steering provisions. So to avoid incurring higher fees, merchants will attempt to dissuade cardholders from using certain cards. In other words, they would steer them to cards that are more beneficial to the merchant. So if they pay 3% on one card but pay 2.5% to the other card, they'll steer them to the one that's more favorable to them. American Express has certain anti-steering provisions to prevent merchants from doing that. The U.S. and several states sued American Express. Sued American Express over these anti-steering provisions, and the issue here was, okay, are the cardholders what are called multi-sided platforms? So in other words, is there a separate market here, or between merchants and cardholders? And I know I'm sort of blurring the lines between a multi-sided platform and a multi-sided market, but I'll make the distinction a little bit later. The court found that the plaintiffs correctly just analyzed only one side of the market. The Second Circuit reversed, and the Supreme Court, in its recent decision, upheld the Second Circuit, finding that American Express operates what's called a two-sided platform, and that both sides, so in other words, the effect on both merchant and card holders must be analyzed when determining the relevant market. So again, this is a step one issue under the rule of reason, and that is something I want to underline because it's going to play a critical role in the NCA case. So what we mean by a two-sided platform is a platform that provides services to two different groups. So in other words, it mediates the relationship between card holders and merchants. So it's the platform, as David Evans and Richard Schmalensky said, acts as a matchmaker between the two sides. So one example of that is so let's say PlayStation or Xbox acts as a mediator between, let's say, Blizzard games and the players. Both players certainly benefit from having more developers on the other side of the market, but the developers also benefit from having a lot of players on that particular platform. The Supreme Court noted that the credit card markets are what are called transactional platforms, meaning they make a simultaneous sale to both sides of the market. In other words, for a transaction to occur, both sides must participate at the same time. So there's the indirect network effects I just mentioned are precisely those that both sides mention. Both sides of the platform benefit from the increased numerosity on the other side. And the two key features that I want to focus on are, or that really the court focused on, are simultaneity and proportional consumption. And simultaneity is what I just mentioned, is that both sides must simultaneously participate, and there's a one-to-one proportional consumption. So there's one merchant, one card holder. Now, in the NCA grant and aid litigation, the plaintiffs are current and former football bowl subdivision and Division I men's athletes, and Division I men's and women's basketball players. The defendants are the NCAA and 11-member conferences, and at issue is it's a Sherman 1 claim, meaning that the defendants, NCAA member schools, have colluded to fix the compensation that's paid to athletes at cost of attendance. The market definition that was used, and it's the same one that was used in the name, image, and likeness litigation in O'Bannon, was the market for college education combined with athletics, or alternatively, the market for student athletes' athletic services. So first of all, I don't agree with that market definition. The way it's listed here, namely college education combined with athletics, that to me is essentially a bundle tie. But nevertheless, that's the operative definition. The NCAA offered two pro-competitive justifications. Namely, number one, that the limits on compensation serve to preserve demand for the product. In other words, there's something about amateurism, there's something about amateur sports that drives demand. Now, that's a particularly specious argument because the concept of amateurism, the definition of amateur sports has changed dramatically over the last 30 or 40 years and continues to change today. But that's what the NCAA has argued. And its second defense is that the rules promote the integration of athletes in the academic life, which again manages to be equally specious because really what the focus on athletics has done is really limit the amount of time available to athletes to participate in the academic life. But nonetheless, this is where we are. The district court, in its findings last year, it agreed that the NCAA was subject to the rule of reason, as before in the O'Bannon case, and that the defendants collusively restrained trade, and the compensation limits produced anti-competitive effects, which frankly was pretty obvious. But the third part was that the pro-competitive justification, which is unlimited, which is preventing unlimited cash payments, such as we see in professional sports, although those are also somewhat limited, but through collective bargaining. Those payments can be achieved through a less restrictive alternative. And again, in this case, the court was bound by the previous Ninth Circuit finding in O'Bannon that any payments to college athletes must be tethered to education. So in this, those were the frameworks within which the district court had to work, and it was the same judge in this case as was in the previous O'Bannon litigation. And when I say O'Bannon, I don't know if everyone knows what I mean by that. That was the name, image, and likeness litigation. In turn, the Ninth Circuit was bound by the Supreme Court's decision, and to go back to this is the 1984 ruling in the Board of Regents. That's reasonable to assume most NCAA controls are pro-competitive because they enhance the public interest in intercollegiate athletics. Now, I take some objection to that because what we just saw here are cross-platform effects that are used as a pro-competitive justification in a monopsony case to offset harm. So in other words, we're seeing the harm to labor in a monopsony case being offset by some ostensible benefits to consumers. But those benefits are really undefined. So how did this survive? So how did we get to this point? And what's interesting is that the court defined this, the record definition the court used was single-sided. Was a one-sided platform, is the same definition as in O'Bannon. So the interesting thing is that the court rejected this multi-sided platform argument, and it excluded the defense's antitrust experts' opinion on the matter. Now, previously, it had excluded the opinion based on the fact that it was irrelevant to the market definition because it was the same market definition as in O'Bannon, so the multi-sided platform argument did not need to be considered. But the Ohio versus American Express decision came down right during while the case was going on, so the NCAA asked the court to reconsider it. And, okay, so this is this is the NCAA's experts' multi-sided platform theory as a pro-competitive justification. And one, I don't mean to pick on the expert, or maybe I do a little bit. I'm not involved in this case, so this is purely a research interest. His theory was that colleges operate as multi-sided platforms that balance pricing to various constituencies. And somewhat problematic point here is that the expert listed all the constituencies on one side, which somewhat undermines his argument, and not to mention the fact that the expert mentioned that, well, we don't really know who the constituencies are. We don't really know what all the constituencies are, nor did the expert explain a whole lot of other critical parts. So in the end, what happened was the district court excluded the expert's opinion. And it excluded that using Ohio versus American Express as the lodestar here, and specifically, it focused on the Amex decision's use of the term transactional platform. So it excluded them because, number one, there's no simultaneous interaction between the two sides, or however many sides the expert decided there were, and there's no proportional consumption. So number one, you don't need one fan for every one athlete. In fact, you don't even need any fans for for a game to occur, nor do you need any athlete involvement when a fan buys a sweatshirt with the school's name on it. So the court found several shortcomings. One, it didn't identify the product, didn't explain how it's priced, and didn't explain what it means by what value each side gets. The expert was careful to avoid using the term price because, well, there's no real price effect here. So that said, what one might think is that it's over, right? That the multi-sided platform is dead and buried in this argument, in this particular case. Alas, no, it has actually survived. It has mysteriously survived to and moved to, sorry about that, I missed that slide. It has survived to step 2. So how did it do so, and what does this tell us about potential future monopsony cases? It survived by sort of disguising itself as a pro-competitive justification. And so originally the NCAA had focused on this as it didn't raise this point as a relevant market definition. It raised it as a pro-competitive justification. It then wanted to go back and say, oh no, wait a second, we really meant this as a step 1 argument under the rule of reason. And now the court excluded it under step 1. So what happened? Well, the other experts, one survey expert and then a labor economist, essentially made the same claim without referencing multi-sided platforms. What they said is, look, our survey shows that fans would watch less if athletes were paid. And number 2, the labor economist claimed there are feedback effects if you pay athletes, there will be feedback effects. In other words, it would decrease viewership, which in turn will result in less money for the athletes. So that feedback loop language is exactly the one that describes indirect network effects in multi-sided platforms. My argument is that, let's go back to Board of Regents and see what Board of Regents said, which is namely that the NCAA plays an important role in preserving the character of this game, of this product, which is amateur athletics. Now, as I noted, the definition of amateur has changed dramatically, and the world that existed when Board of Regents, when the Board of Regents was decided is very different than now. But 2 points here that I want to make just very briefly. Number one, this is dicta. So this is a peripheral, this is essentially the court editorializing here regarding the NCAA. This is not relevant to the key issue in Board of Regents. And number two, that look, if we don't, if fan demand is not necessary and absent indirect network effects, this is really just a single-sided market. So where do we go from here? It's the consumer demand is a key pillar of the NCAA defense. Really, everything that upholds NCAA amateurism rests on this particular theory. If the consumer demand theory falls apart, the NCAA is done. And so my point is that, well, the Ohio versus American Express case now renders the consumer demand theory entirely irrelevant, and that's it. Sorry.
Thanks very much.
Okay, hi everybody. My name is Elinor Hoffmann. I'm with the New York Attorney General's office, and I want to make clear that anything I say here today represents my views only and shouldn't be imputed to the New York Attorney General, Letitia James, or any other member of her office. So first of all, I want to thank Catherine and Mark for inviting me here. It's beautiful here. It's a little colder than New York, but I love mountains, so I'm really pleased to be here, and I want to echo something Tim said earlier. It is really good to have these conferences outside of Washington, outside of New York, outside of the East Coast. I think it's great to interact with the rest of the country, and we are a little bit East Coast centric where I come from, so I'm very, very happy to be here and very, very happy to see all of you. So I think it was Marshall who said earlier that antitrust has been a little bit sleepy over the past, 50 years. I don't really think so, but then again, I've been deeply involved in antitrust for a long time. But certainly there are aspects of antitrust where the interest has kind of ebbed, flowed, and changed. And labor, the interface between labor and antitrust is one of them. So I've had a really long-standing interest in that interface. When I first started law school, I was going to be a labor lawyer. Then I took a course in labor law with the local head of the NLRB, and I decided I was not interested in what he was talking about. I was not interested in the NLRB, and I dropped the course. When I joined a large law firm after graduation, I chose the antitrust group by essentially default. A friend of mine who was there, a guy named John Jacobson, who some of you may know, told me that the people were great and that the subject had political, social, and also economic impacts. And I thought that sounded really good. And I was interested in politics. I was interested in social issues. I don't know whether I was that interested in economics, but I learned a lot. And I had never taken an antitrust course, so maybe that was, that I don't know which way that it would have pushed me. But anyway, I joined the antitrust group and have never looked back. So coincidentally, one of my major projects as a young associate was advising a multi-employer group that was involved in collective bargaining in a highly unionized industry with a labor union. And my function for this client was to advise the client of the risks attendant to negotiating as a group with a labor union, something that we now recognize is called the non-statutory exemption to the labor laws. So I got really interested in this, and I even wrote an early law review article about it. But here's the issue. So in the beginning, back in 1890, Congress, when it was looking at passing the Sherman Act, wanted to address the problems of large firms, combinations, monopolies that increased the price of products to consumers, but that also suppressed the wages to labor. You have to think back, 1890s, period of populism, incipient labor movements. So that was very, very much on their minds. And if I can find the correct quote here, the kind of combination would be that Congress wanted to address would be one that could control the market, raise or lower prices as will best promote its selfish interests, dictate terms to transportation companies. It commands the price of labor without fear of strikes, for in its field it allows no competitors. So that's what Congress was thinking about in 1890. Of course, things don't always work out as expected. And during about the first quarter century of the Sherman Act, the antitrust laws were used often to attack labor organizations or incipient labor unions. So, for example, in the case of Lowe v. Lawler in the Supreme Court in 1908, the court said, fundamentally, the antitrust laws treat robber barons and labor the same way, and where labor organizations or competitors who get together to fix the price of what they're selling act in concert, that should be unlawful under the antitrust laws. And specifically, the court said, the act makes no distinction between classes. It provided that every contract, combination, or conspiracy in restraint of trade was illegal. And it found that a combination that was trying to essentially form a union in the area of manufacturing for hats was unlawful. That's also called the Danbury Hatters case. So Congress was not very happy with that, or at least some people in Congress were not very happy with that. And in 1914, in considering what later became the Clayton Act, Congress passed a statute, Section 6 of the Clayton Act, which exempts labor organizations from the application of the antitrust laws. And the act begins with the profound statement that the labor of a human being is not a commodity or article of commerce. And we know that, we agree with that. It is a strong moral and philosophical statement. The senator that wanted that statement included is Senator Cummings, a Republican from Ohio. And he said, it disturbs me to hear labor termed a commodity, to hear the power of a man or woman to exercise the strength of mind or body in the production of something useful, confused with the product which is the result of that exercise. When labor unions are declared to be outside of the antitrust law, we are simply recognizing the essential character of things and are making a legislative declaration or interpretation of the law rather than classifying the people of the country and allowing one class to escape and another class to be bound. So he was very much aware of the Supreme Court's language in Lowe v. Lawler in the Danbury Hatters case and wanted to make clear that he knew what he was talking about, but this was the purpose of this statute, and it's quite clear, is it really only protects labor organizations, labor unions. It promoted the formation of our national labor policy, which is focused on collective bargaining. So, what's happened since then? There's been a lot of litigation. There were a lot of cases involving the scope of that labor exemption, the statutory labor exemption, and it was, I think, the late 70s or early 80s when the Supreme Court decided a case that created what's called the non-statutory labor exemption, expanding judicially a form of that exemption to employer groups when engaged in collective bargaining with the union, again, to promote the national labor policy and collective bargaining. But lately, in the past few years, we've been thinking about labor from the other side, which is, okay, labor organizations are exempt, but that doesn't mean that labor workers, whether they're selling physical labor or labor of the mind, are not important stakeholders in the commercial marketplace. And like any other stakeholder in the commercial marketplace, workers can be hurt by anti-competitive conduct. And disruption of the competitive process, and I happen to like that term, Carl Shapiro used it before, when testifying before the Senate in 2017. Tim Wu has used it in many of his articles. Disruption of the competitive process can hurt labor. So we've been looking at it kind of in three contexts most recently. One is I'll call roughly the no-poach agreements. No poach, no solicitation, no hire, even non-competes. And this kind of falls into different categories. One category are horizontal agreements among competitors, not to solicit employees from one another. The Department of Justice challenged those kinds of agreements involving highly skilled employees in US v. Adobe, and has since said publicly that they will challenge such agreements as criminal conduct under Section 1 of the Sherman Act, a per se violation of Section 1 of the Sherman Act. Another kind of agreement is more vertical in nature, and we see this in the franchise industry, the fast food industry, where franchisors include provisions in their contracts with franchisees saying that you can't solicit or poach employees from your fellow franchisees. Like any vertical agreement, it has horizontal impacts, but the Supreme Court told us in Legion that agreements that are primarily vertical are judged under a rule of reason. Now, in some cases, there are franchisor-owned franchises that compete with other franchisees, and those are clearly horizontal, would probably fall into the same, horizontal bailiwick as US v. Adobe. But there are others where that's not true, and the Justice Department has intervened in private cases to make the point that they think those kinds of agreements should be judged under a rule of reason. Others, the state of Washington has said under its state law, they should be subject to a per se test. Others, including Steve Salop, for example, believe they should be subject to kind of a presumption of anti-competitive effects, a quick look, because he says, and I think this is true, many people agree, that it's very hard, especially when you're dealing with sort of unskilled workers or not highly trained workers, to think of a plausible pro-competitive justification for that kind of conduct or that kind of clause. So that's very much in the news. A number of states have settled with, I think, 60 different fast food enterprises, and those companies have agreed not to enforce no-poach clauses, which makes one wonder what is the importance of it to their business in the first place. Another context in which harm to labor has arisen, and is exclusive contracts or the exercise of monopoly power over workers. There's one case being litigated now that Hal knows well, involving the Ultimate Fighting Club or Ultimate Fighting Competition, Ultimate Fighting Championship, I can't remember what it is, UFC. Anyway, a group of highly skilled athletes, multifaceted athletes, have challenged the exclusivity provisions in their contracts that prevent them from moving to other leagues or from negotiating a greater share of the profits from these kinds of competitions. That case is in litigation. I think there's a summary judgment motion pending. There's a class cert motion pending. It's the only case like it that I know about, but it could have important consequences. One question is whether, there's kind of a chicken and the egg thing going on here. Do they have to prove that this is actually a monopoly in order to win? Or is it that there's no competition to this league because of these exclusivity contracts and there are not that many multifaceted athletes of this caliber around? So finally, the third context in which we've begun looking at effects on labor are mergers. And there is no litigated case where an impact on labor has caused a merger to fail. But increasingly, the question comes up, should we be looking at these kinds of impacts? It raises a whole bunch of questions which need to be studied more for all you academics out there. For example, how do you define markets? We know that labor markets are not necessarily coterminous with product markets. Hypothetically, let's say Amazon and Microsoft decided to merge. They don't really sell substitutable products or services. Maybe on the fringe they do, but mostly no. But they both are located in Seattle, and maybe they compete for some highly skilled kind of computer engineer. So the labor market could be quite different. Another issue is the early research has pretty much shown that labor market effects occur mostly in situations where there are also significant product market effects. So is it worth, for example, our enforcement dollars to go look in, specifically for labor market effects, or are we going to find those in cases where there are significant product market effects? So there's some research that's been done. Nancy Rose and Scott Hempel wrote a very good paper on effects on sellers, on the effects of mergers on sellers. There was a really interesting deep dive into the hospital mergers by Elena Prager of Northwestern and I think Matt Schmidt of UCLA, where they found that there was less wage growth among highly skilled healthcare professionals in situations where there had been hospital mergers, but they didn't find a similar effect on unskilled workers who worked in those hospitals. And I think we need a lot more industry-specific research in this area. And then finally, the last point I want to make comes back to consumer welfare. So the big picture issue is, are labor markets or harm to labor part of the consumer welfare calculus? There's a lot of discussion about what consumer welfare should and shouldn't include, and we need a whole other conference, University of Utah, on that. Another time, and there have been many. But certainly, I guess pressing wages could mean lower prices for consumers, but does that mean that we shouldn't look at it from an antitrust perspective? I would say that just because we can't measure everything doesn't mean we shouldn't consider it. And in every challenge lies an opportunity, so maybe we have to figure out better ways to reduce impact on labor markets, to kind of a methodology where we can go into court, present evidence, and make a case. Thank you.
So I'll just start off by saying thanks for inviting me. It's really exciting to be in a room with this group of people. Can you hear me all right? Okay, actually, now that I yell into it, that'll help. Okay, a little too tall for this mic. So like Catherine, I'm a labor economist that kind of stumbled into antitrust. And I think part of the reason for that is, what's a labor economics regression? You put your worker characteristics on the right-hand side, you put wages on the left-hand side, and see, sort of read off what determines wages. And firms really aren't there. You might have occupations in there, but not firms. But once, and as we know, firms do affect wages and working conditions quite a bit. Then we have to get into IO, and we have to get into antitrust. So I think it's a really exciting sort of area. So I'm going to be talking about a sort of narrow area of this that really isn't even antitrust law anymore, since all these things that used to be illegal are now legal. But I'm going to be talking about vertical restraints, which are the essence of franchising relationships. So I probably don't have to do the definition for this room, but just for anyone who's not a lawyer or an economist, a vertical restraint is a competition restriction in contracts between firms or individuals at different levels of the production and distribution process. So things like resale price maintenance or territorial restrictions and things of that nature. They were of questionable legality under antitrust laws pre-1997. I'll get into how that changed in a bit. But again, vertical restraints are what franchising is. 1 in 16 Americans works for a franchise establishment. It's a big part of the economy. And things that franchises do tend to bleed into other businesses, such as like Uber and Lyft and the so-called platform economy. So basically, in franchising, one firm licenses another to operate businesses under its trademark, so like a McDonald's or a Jiffy Lube. And of course, if McDonald's is going to license Joe's LLC to sell hamburgers to the public, they want to have some say in over how those hamburgers are made and how the signs look and all that kind of stuff. So they impose these vertical restraints on the franchisee to tell them, basically in pretty minute detail, how they run their business. And the common vertical restraints that we see in franchise contracts are things like resale price maintenance, maximum or minimum prices, in other words. Non-competes. We see no poach agreements. We see restrictions on resale of the franchise, so the franchisees get sort of locked in and they can't leave. We see supplier restrictions. Sometimes up to 80% of the suppliers, the franchisee's supplies come from sources they can't control. Location restrictions, mandatory hours, and even fixed capital investments. And just as an aside for the economists here, I think that's interesting because franchisees are legally separate firms, but they don't have residual control rights over their own assets. The franchisor can force them to make investments according to assets that they hold title to, which I think is interesting. Double doing it. So first, I want to point out vertical restraints and monopsony actually go way back, like to the beginning of capitalism. They were an important tool of monopsony and labor discipline in the first factories in England in the 18th century. Marglin's What Do Bosses Do paper in 1974 pointed out, I actually didn't know about bullet point 2. I had read Marglin years ago. Suresh Naidu pointed this out in a presentation a couple weeks ago, so I should credit him too. But I read the paper and it's there. So what the factory system did, right, is it didn't just increase efficiency with like new machines and stuff. They didn't have the machines. What it did was it brought previously independent producers into a centralized place where the boss could look at them, monitor them, make sure they're working, they're not stealing, all that kind of stuff. And it imposed vertical restraints on those independent producers so they could not contract with other potential employers. And with the criminalization of breach of contract under master-servant laws at around the same time, these vertical restraints were quite powerful as tools of labor discipline and monopsony. So jumping into the present, very schematically, I know any historians or lawyers will point to problems with this, but very schematically, we sort of, right, when the corporation first became an institution that we just started to notice, with railroads and then other companies in the late 19th century, with the Progressive era and then the New Deal era, we came up with ways to sort of socially control them and regulate them because corporations are great because they generate tons of wealth and we like that they do that. But they also tend to like shoot workers that go on strike, or they raise prices too high, or they buy off politicians. Like there's a lot of things that like aren't so great about corporations. So we had antitrust law that at least in the post New Deal era, post Thurman Arnold era, was there to really protect consumers and more controversially also protect small firms, though it did that too, from concentrated corporate power. And then we had labor laws to protect and state-backed labor market institutions, unions, to protect workers from the same thing, concentrated corporate power. And then we had, like investors were protected by the securities laws. The environment even got its own agency. So there's this whole regulatory apparatus assumes a firm as a vertically integrated organization that owns assets and employs workers. We're assuming that a firm is U.S. Steel. And so firms immediately, I mean, this did not happen recently. As soon as these laws were passed, firms started creating, at that time, they were called dual economies. Now we call them fishered workplaces or domestic outsourcing to get around these laws, to try to not be regulated the way that the laws intended them to be regulated. And this takes the form of things like hiring workers through temp agencies rather than directly hiring them. The auto industry immediately after the NLRA, started spinning off parts manufacturing to smaller firms. So the innovation of franchising was, these are like in the new industry at that time in the 50s of fast food, they figured out a way to get really big really fast and centrally control a production network just like a vertically integrated firm, but through contracts rather than owning assets and employing workers. So they had a different mechanism for exercising economic control, and this was noted very widely at the time. You read the proceedings of any antitrust conference in the 1950s or 60s, and they'll talk about vertical restraints as a substitute for vertical integration. So what they were able to do is use vertical disintegration in the legal sense, right? Spin off subsidiaries or sell your hamburgers through franchisees rather than directly owning the restaurants, to shed the risks and costs and legal obligations that went with owning assets and employing workers. But at the same time, they could use these vertical restraints to achieve integration equivalent levels of control. But the problem was vertical restraints had a very uncertain status under the laws. There's a series of very confused court rulings because the courts can't decide, are we here to protect small businesses? Is it about low consumer prices? They don't know what they're supposed to do. So franchisors didn't really know if what they were doing was legal. But I want to point out that this isn't something that we just discovered this year. People noticed at the time that there was something a little untoward maybe happening with this. So oil companies, after the passage of the Fair Labor Standards Act, they went to something called the Iowa Plan, which is they used to have gas station attendants, people that pump your gas and all that stuff. They got rid of all the gas station attendants and made them independent contractors. And then they would do things like give them one-year contracts and say, we're not going to tell you what price to charge because that would be illegal. And we're not going to tell you what batteries and tires and accessories you have to sell because that would also be an illegal vertical restraint. But your contract's up in a year. So if you don't charge our price, so the Teamsters tried to organize these guys in the 60s, and they complained to the House Small Business Committee that oil companies had what they called double-barreled immunity from both antitrust laws and labor laws, because as independent contractors, they could not unionize these gas station attendants. But also, the oil companies found a way to control the activity of these independent dealers without formally imposing vertical restraints. And then another example I'll highlight is this is Jerry S. Cohen, at that time the chief counsel to the Senate Antitrust Committee. For any labor people, that's a different Jerry S. Cohen from the general counsel for the farm workers. It's very confusing. They have the exact same name. The New York Times even confused them in the obituary, said one guy died and the other one did. Or actually, no, they were the same person. It was kind of embarrassing. Confused me, too. For a couple of years, I thought they were the same guy, but they're not. So anyway, so this is Jerry.
Wayne State, by the way.
What's it?
He's a graduate of Wayne State Law School.
Wayne State. So Jerry S. Cohen, this is an exchange, I have it up there, where basically the president of the International Franchise Association has just said, we need small business to survive, and small businesses only will survive as part of franchising. So we should, to allow franchising to survive, we should be able to control our franchisees to the same extent as a vertically integrated corporation through vertical restraints. And Cohen is somewhat incredulous, and he asks him, well, wait a minute, if a franchisee is told what product he has to buy, what prices he has to charge, what operation he has to operate in, then he's not an independent business, is he? He's an integrated part of your operation. He's inside the boundaries of the firm, so to speak, but you're not owning his assets or employing workers, but you're controlling them just the same. So I have a paper that I think is the one, if you click on my name in the conference program, it's forthcoming at Enterprise and Society, where I sort of trace this history, and I argue that the legalization of vertical restraints, which created franchising, and these other bodies of law that created franchising, was a concerted lobbying and litigation effort, particularly by the International Franchise Association. And they started off by, the Small Business Administration would not extend loans to franchisees when franchising started, under the reasoning that, look at these vertical restraints, these aren't independent small businesses at all. These are just distribution outlets of an integrated corporation. So they refused to give them loans. But after a couple rounds of lobbying from the Franchise Association, they revised that standard in 1966. And then the IFA hired the general counsel for the Small Business Administration to be their general counsel, which role he held until 2017. And then a second example is labor law. So franchisors were very concerned that by controlling their franchisees in this way, through vertical restraints, that they would trigger either that the courts would find that the franchisees were employees of the franchisor because of the vertical restraints, or that the employees of the franchisee were under joint employment doctrines, right? That McDonald's workers should be actually allowed to collectively bargain with McDonald's, because that's really what's determining their working conditions, right? And there's a bunch of cases, but in the first time the Labor Board rules 1968 in NLRB versus RWDSU, vertical restraints do not make franchisors joint employers as long as they don't directly set wages or hire and fire workers. Well, the big one, of course, is Continental DV versus GT Sylvania, which is considered like the big victory of UChicago law and economics antitrust. But if you look at this is a franchising case. Franchisers were pushing this. GT Sylvania was a franchisor. If you look at the amicus briefs, it's all franchisor associations that are concerned with this case. The only people that really were noticing at the time was franchisers. They were pushing really hard to legalize vertical restraints. And the outcome of this case is it basically allowed franchisors to control franchise. It removed all the legal uncertainty about vertical restraints. It's like, now we can do it. There's no longer a risk that non-price vertical restraints. The price vertical restraint relaxation, of course, came in 2007. And then the final sort of nail in the coffin for this was the Federal Trade Commission's franchise rule in 1979. So much like you see with like AB5 in California now with platform workers, franchisees like, okay, so we're not workers, we don't have any rights, but if we can't be covered by the labor laws, can you give us something else? So they were looking for some kind of restrictions against the obviously lopsided power that the franchisors had over them. And the FTC said, no, you don't get that. What we'll give you is a disclosure regime. And what that meant was that as long as franchisees were fully informed about all the ways they might get screwed, that's it. That's the whole statute. It's just a disclosure. It's a consumer protection, basically, kind of regime. So I want to pivot to another paper just in the last couple minutes. This one, actually, I just got the referee report, and the reviewer 2, it's a revise and resubmit, but reviewer 2 is very unhappy at how neoclassical the paper is. So I am a neoclassical economist, and I'm speaking to you here today as a neoclassical economist. And with apologies to Margolin, I just want to take a step and look at these contracts, and what do franchisees actually do? What are they doing when they're facing these kinds of contracts? So I think, I guess in a neoclassical way, I think we should look at the incentives of vertical restraints. Franchise contracts are principal-agent relationships in the economic sense, not the legal sense, in the sense in which you have a principal, the franchisor, who has an agent, the franchisee, and the principal wants the agent to act in a certain way that's in the franchisor's interest. But the agent has their own interests they might pursue that are counter to the interests of the principal. For example, the franchisee might want to pay their workers a little more than the franchisor would like. Or they might want to substitute, cheaper meat than the high quality, stuff that you get at McDonald's. Which actually, if you've been there since they've switched to fresh meat, it's actually very good. It is. McDonald's is up there with Wendy's now. So by controlling, but I think that if you just think about what's being outsourced. If you see a franchisee who can't set their own prices, they can't choose their own suppliers, they can't choose their own hours of operation, they don't do the marketing, they don't do the product development, what are they doing? And I think what's being outsourced is labor discipline, right? It's like the old sweating system in the garment industry, where you have these guys who what's being outsourced to them is they hire and fire, and they surveil, and they make sure everyone's working as hard as they should be working. And that exerts downward pressure on wages. That through any of the efficiency wage models, the better the boss's information about the workers' effort levels, that's going to reduce the wage premium that workers get to get them to exert any effort on the job. So I think that by controlling everything but wages through vertical restraints, I would argue that franchise contracts compel franchisees to squeeze wages as low as possible. And I think a notion I learned recently from sociology, actually from my colleague Iha, so it's a benefit of interdisciplinarity as you work with people from other disciplines, you learn their stuff. Refractive surveillance, like when you rate your Uber driver, you are helping Uber monitor that driver. But Uber doesn't monitor the driver directly, so they're not employers. So similarly, the franchisor surveils the franchisee and watches them to make sure the franchisee watches the workers. So the franchisor controls working conditions and wages by controlling another party that actually does that for them. But they avoid the legal responsibilities of employment. And I think another thing, I think this is an area that I just make a sort of almost a plea for us labor economists, is that I think this happens without monopsony, the way that we sort of understand it. It's not employer concentration. It's not heterogeneous worker preferences over job amenities. It's not search frictions. It's not, I think, the way I think of most monopsony models is sort of about the turnover wage trade-off sort of facing the firm. And maybe I'm misunderstanding this, but I think it would help if we could supplement the monopsony model, and also it depends on the labor market external to the firm. But if we could supplement the monopsony models with another class of models, the labor discipline or efficiency wage models of Bowles and Gintis, Shapiro-Stiglitz, Scott and Guy more recently, these are models that depend on the structure of the workplace. They depend on the surveillance and the information that the boss has over workers. These models rely on principal and agent issues. But I think if we could integrate them with the monopsony models, might provide a more powerful example of ways that bosses determine wages and suppress wages that isn't necessarily a monopsonistic model. And also, sort of echo and amplify Lena Khan's comment from this morning about anti-monopoly is not just antitrust. There may be other remedies here besides just the traditional antitrust remedies. For example, supplement antitrust law with joint employment law. So, or expand it to things like Sanjukta and Sandeep have talked about, of expanding other groups, not just workers' ability to collectively bargain or to, in other ways, sort of countervailing power is the word I'm looking for here. Countervail the power of big corporations. And I think that's it. Yeah.
All right, so in the interest of time, I'm gonna get right into it. Can you hear me okay? I think Brian's presentation was a really good, period, and then also just helps to broaden what we're talking about when we're talking about the intersection of labor and antitrust, and what we're talking about when we're talking about antitrust should care about labor markets. I am interested in recreating antitrust from a worker perspective, not in the first instance in extending antitrust in its current form to, just keeping track of my time, to labor issues, something that I think is as likely to make bad situations worse, frankly, than anything else. And I absolutely think there's a lot that a reconstituted antitrust can do that's relevant to workers and work. So Marshall talked this morning about bomb throwing, so let's throw some bigger bombs for the last panel of the day. I would posit that antitrust law is not most fundamentally about what we think it's about, promoting competition, but rather it is about something rather different. I would call that function allocating economic coordination rights. In other words, who gets to participate in the coordination of the economy? I think this is, so let me say two things about this. First, this is in the first instance an analytic claim and not a normative claim. This is not something I'm saying antitrust should do. I'm saying this is what it does now. And it has certain criteria for doing this. I and other folks think that maybe it should have some other criteria for doing this, but to have an honest debate about this, we first have to reframe, and that is my first contention. Antitrust law already does this, whether we like it or not. Economic coordination is inevitable. Antitrust decides who gets to participate and how it is to be accomplished. Now, certainly other areas of law do this as well. Labor law, corporations law, to name a few just are ones I happen to think about, but also local coordination of markets. But many times antitrust law holds a trump card as to those other areas of law, and so it's particularly important. The other thing is that the fact that antitrust does this, and the fact that we largely don't think or talk about it this way, actually has a really insidious consequence for labor and workers that goes way beyond the gig economy or any of this. No area of law has been more a fortress for sort of orthodox law and economics than antitrust law. And there is a common notion that is embedded in the paradigm of law and economics and that pervades legal and policy debate. So you may think this is very theoretical, but this pervades policy debate, right? Including among fairly liberal Democrats, that collective bargaining mechanisms and even public coordination of markets through, say, minimum wages and working conditions, in some sense, as an initial matter, distort market outcomes and are therefore inefficient, though they may be justified by countervailing considerations. This position immediately sets up a kind of presumption against labor coordination or against public coordination of markets to benefit workers, a presumption that is analytically and normatively supported by law and economics. Too often, I posit, progressive and even left responses have been limited to asserting that considerations other than efficiency should be balanced with efficiency concerns. Maybe we should also care about fairness or humanitarian concerns, or maybe worker voice and living wages are indeed efficient because they correct market failures. Some critiques also rely heavily on the idea that labor is different from other commodities, which tends to imply that we can understand everything else as a potential commodity. At the same time, antitrust law is an important way into dissecting this conventional policy thinking about labor coordination, and antitrust intersection with labor is a particularly promising location, I believe, to begin pulling on these threads, which hopefully may help to unravel a much larger portion of this analytical framework that goes way beyond antitrust and labor. And the reason for that is because antitrust interaction with workers and labor markets illustrates especially well how antitrust and law generally allocates coordination rights. So let me say a little bit about that. The dominant framework for antitrust law and law and economics, I would say more generally, legally privileges the forms of economic coordination that are embodied in the traditional business firm and also in a number of business arrangements controlled by powerful business firms, as we saw so well in Brian's presentation, while at the same time rendering these forms of coordination analytically invisible in a certain way. Labor coordination, by contrast, is both highly visible and disfavored in this analytic framework, even though it is nominally legalized by labor law and by the labor exemption to antitrust law. And we can see this kind of analytic and normative ordering between labor law and antitrust law in legal and policy debates about how to resolve uncertain areas of law. Okay, so very briefly, because I think Brian did such a nice job of giving examples of this, the current criteria for allocating coordination rights largely favor top-down hierarchical control while frowning on more widely dispersed coordination, that is, cooperation among smaller players. There's a logic to this. And so there's some examples. The treatment of vertical restraints versus horizontal coordination beyond firm boundaries we saw so clearly in Brian's presentation. I would add to this the privileged status of business firms themselves. You may think I'm crazy for bringing that up, but also Brian explained how the firm itself is and the business corporation is a contingent legal entity that really in its current form wasn't created until the business trust that antitrust law was passed in response to were the precursors of the modern firm, and then they've sort of merged into the current firms that we know in the 1890s. So I'll say a teeny bit more about that because I think I am going fast enough to have time to do that. Okay, so, but thirdly, also antitrust law supplies its own criteria for deciding what a firm is in the first place. So for example, many worker cooperatives would not actually qualify for firm status because firm status requires centralization of ownership and control and kind of a sort of top-down organization of firms that sort of tacitly assumes investor-driven, manager-controlled firms. And then fourthly, we see this, the criteria that favor top-down hierarchical control while frowning on democratic cooperation. The fourth example, so again, it was vertical restraints, the firm exemption, as I call it, the criteria for deciding what a firm is, and then fourthly, these contradictions of the gig economy, which is what I set out in the paper that was linked here. But I really want to emphasize that what's going on in the gig economy and the differential treatment of Uber drivers and Uber's price fixing itself, which I don't feel like I need to rehearse again because many of us have explained it many times, that actually is just the current iteration of something that has been going on for some time in these other legal forms, right? So this is just the latest stretching of this, and if we normalize these legal categories, that will become normalized just as vertical restraints were normalized. Okay, so can I just suggest an alternative way of approaching the allocation of economic coordination rights. And so fortunately, we can actually look to the origins of the Sherman Act itself for this. And we can find an affirmative alternate vision in these origins, informed by the legal and market conditions of the time, that is in many ways an inversion of the basic assumptions of antitrust thinking today. So I have to give you a little bit of background to explain this. First, we have to think about markets, economic coordination, and firms in the time leading up to the actual legislative history of the Sherman Act. Local and regional manufacturing economies were transformed, we know, at various stages during the 19th century, and previously that kind of production had been embedded in traditional market regulation and vice versa. Sociologist William Roy puts this point really nicely, quote, "Most industry was organized in local or regional communities that effectively prevented market dynamics from consistently undermining collective interests." I would only restate this slightly by saying that because market dynamics always involve coordination of one sort or another, there's no such thing as markets without coordination, traditional market dynamics were just a different type of coordination, one that was not housed exclusively between firm boundaries. We had relatively autonomous workers who set their own work rules. We just did not, ownership was dispersed in a completely different way. We didn't have sort of owner-managed firms, certainly in material production, the way that we do now. And that was a transformation that happened as the workshops transformed into the firms. And the early labor movement was aimed at that, not at just sort of getting collective bargaining rights as employees, as many of you I'm sure know. Production prior to this and the legal structure of that involved economic coordination that was both outside the firm and those structures were structures in which work and ownership were frequently not separated in the way that we now associate both with firms and with the legal and social category of a worker. And in both senses, at least for many people, many working people, economic coordination rights were more widely dispersed across a greater set of participants. I think this is pretty uncontroversial. Now, second background point, the common law, the background to the legislative history. The common law largely reflected and confirmed this ecumenical attitude to a variety of forms of economic coordination, not exclusively contained within business firms, and it's well known that the common law of restraint of trade, a key concept on which legislatures drew in drafting Section 1, did not condemn horizontal price coordination beyond firm boundaries out of hand, although that is today considered the supreme evil of antitrust. A little bit on corporate law. Corporate law was in transition when federal antitrust law was passed. The transition was already well underway, but really crystallized in the 1890s, culminating in the revision of New Jersey's Corporations Code in that decade. Prior to the completion of that transition, business firms and the source of their powers to engage in economic coordination were understood quite differently from how they're understood today. The public source of that right and the status of the corporation as a franchise was much more foregrounded in both popular and legal consciousness. However, the new corporate law order eventually recharacterized these corporate law privileges or corporate privileges as private rights, thus obscuring the role of the state in conferring them. The new order also generally expanded the legal privileges of shareholders relative to workers, creditors, and the public, and it conferred legal privileges that facilitated the centralization of power among shareholders in a way that likely benefited the emerging national financial elite, also not something that existed before sort of the 1880s and 1990s. Okay, so finally, the trusts. The trusts, what were they? They were business associations that were national or near national in scope and which themselves have helped to bring into being the national markets that we know today. They were also creatures that bridged these two corporate law orders. As business and legal arrangements, they were necessitated by the old order, which put limits on direct merger and asset acquisition across state lines in many instances, and upon firm size and many other things as a matter of state corporate law. So the trusts were, on the one hand, necessitated by the old corporate law order, but their activity helped to presage the new coming corporate law order. It's kind of interesting. Explain that. So the trusts were also the templates for the emerging mega corporations that would define the modern American economy for decades to come. All of this brings us to the legislative debate and the question of legislators' view of economic coordination generally and labor coordination specifically. Legislators were responding directly to the rise of the aforementioned creatures, the business trusts, and they were responding also directly to the farmer labor-led anti-monopoly movement that was protesting the centralization of coordination rights in these brand new things. They said many times that this is what they were doing. We're trying to address this new evil to the nation, the trust, and we're responding to the concerns of these workers and farmers who are bringing this, right? So this leads quickly to the inference, which is supported by what they said, that legislators disfavored the economic coordination typified by the form of the trust and favored the dispersed economic coordination embodied in the farmer, labor, and anti-monopoly movement, which was as much about cultivating solidarity among the many as it was about breaking up economic control by a select few. The anti-monopoly coalition was not concerned only with wages and working conditions, but with inequality and economic coordination rights themselves, which had robbed many workers of their erstwhile autonomy and independence and had robbed others of the post-emancipation promise that they too would have it. Numerous statements by legislators show that they were affirmatively concerned about this concentration of coordination rights in too few hands. That was the problem with the trust, not just consumer prices or competition as such. On the other hand, dispersed forms of economic coordination by farmers, small producers, and workers did not pose this problem. We have long known of the many statements by legislators to the effect that they did not wish to target worker or farmer coordination with the bill. And often they added, these are precisely the people who want to help with this bill. But I would suggest that reconceptualizing antitrust law as fundamentally about allocating coordination rights helps us to see these statements as an essential aspect of an affirmative vision, not as special exceptions or worse, interest group placation. On the other hand, a failure to see this, along with the simultaneous naturalization of large firm-based coordination, is what led to the well-known judicial construction of legislative intent that we already heard about as targeting labor coordination in key Lochner-era decisions like the Danbury-Hatters case. And this Lochner-era crafting of our legal categories of coordination has been with us, albeit in modified form ever since, I think, Bork basically built on these implicitly. Unseating law and economics requires contesting them, and contesting them requires seeing them in the first place.
All right, well, thanks for having me. Thanks to Marshall and Ted for inviting me here. And I, speaking of coordination, Sandeep and I coordinated on which papers we were going to comment on. And I took Ted and Elinor's, and Brian and Sanjukta's will be taken by Sandeep.
I think we committed a per se violation.
This probably. And besides, I hosted a Bytes chat that took a deep dive into Sanjukta's paper in the context of Uber, and I commend you guys to read that if you're interested. I feel like I've shown enough attention there. So let me spread the love around, and I'll start off with an overarching theme that I think comes through today's panel, this panel in particular, but I keep hearing. I want to make it really crystal clear, and that's this notion of offsets in antitrust. And what's happening now in the Amex case really crystallizes this, is this notion of what constitutes an efficiency that would allow a defendant to escape what would otherwise be a violation of the antitrust laws. And what defendants increasingly like to do is to point to benefits that flow from the restraint that in question that's being challenged. And not only on those parties who were injured by the restraint, but by a discrete and separate set of parties. And say, look, maybe I did something wrong over here with respect to, say, workers, or in the Amex case with respect to merchants. Maybe by imposing the no surcharge restriction on merchants, effectively a gag order that prevented them from telling their customers that they could save if they used a cheaper card. Maybe I did this over here, but Your Honor, there's a beneficiary over here, which is the cardholder. And you have to understand that I took some of those overcharges and I splashed them onto the cardholders And as a result, you need to weigh those harms and those benefits, and ultimately decide if on net I did a good thing from society's perspective. Sanjukta speaks of the firm exemption. I'd like to call what the Supreme Court did in American Express, well, I have a few different pet names for it, but one idea is that one is kind of long. It's the two-sided transactional platform exemption to antitrust. That sucks, so we have to do something better than that. I want to try another one out on you, which is the Centurion exemption. And if anyone holds an Amex Platinum card, you'll get the joke. Does anyone have that thing? Anyway, maybe I fly too much, but what this does is it gives you access to the American Express lounges in airports. And there's some wonderful cardholder benefits that go down in those lounges, including the restaurants are done by Michelle Bernstein, who's a James Beard award-winning chef, and you also get free massages. So these are the, I'm serious, and so, so these are the benefits that Amex gets to preserve, and effectively they were granted immunity from the antitrust laws because of the splashing of these benefits. So think about the Centurion exemption. We can come up with something else, but now you know what I mean by the Centurion exemption. Elinor's piece, I'll turn to first. Oh, I feel like in the name of bomb throwing, well, I don't know if this is a bomb throw, but it effectively is an assault on antitrust enforcement. I mean, that's what the Amex decision is. And you have to understand what's going on. I mean, they are trying, a very conservative court is trying to peel back the enforcement of antitrust. You know, they put you through all these paces. You have to identify a restraint, and you have to connect the restraint to a tangible and measurable harm, which the plaintiffs did in that case. They showed that the no surcharge was causally connected to an inflated merchant fee, a recognized harm under the antitrust laws, and that was not sufficient. So there's my bomb throw for you. I don't know if it's there, but it's literally an assault on the enforcement of the antitrust laws. Now I want to move over to Elinor's piece. She mentioned two cases which are, of course, very near and dear to my heart, and probably why I'm on this panel, which is the UFC Monopsony case and the McDonald's no poach case. And I would love to comment on those cases, but I think if I did, my handlers would probably send some very large men up here and pull me off the stage, because those are currently in motion. But we can talk about a hypothetical case that I feel more comfortable speaking of, and it's a question that Elinor teed up, and I just also want to crystallize this as well, which is, imagine that we have a restraint that is imposed by a firm on its employees, and some economist has been able to demonstrate that restraint is causally connected to the suppression of wages of the workers, right? And the question is, would that evidence constitute a violation of the antitrust laws? I sure hope it does. But imagine the defendants say the restraint was necessary in order to preserve the proper functioning and demand of the product in question. And while it may be the case that our workers were harmed as a result of this restraint, say that they weren't allowed to compete with a rival platform for 40 months, that we needed to do it to create a benefit for our viewers, right? And the question is whether or not that offset, if you will, to come back to my favorite word, is something that a court should be willing to consider as a way to excuse what would otherwise be a violation of the antitrust laws. And Elinor in her piece says, I think she's asking, what's the case? What's the case that you would cite if you were the plaintiff's lawyer to say, no, Your Honor, I want you to close your eyes to that offset, and I want you to limit any consideration of efficiencies just to those parties who were harmed by the restraint. I don't know if there is a case out there. Maybe you guys can help me when I pass the baton back to you. And now I know through Amex there is an affirmatively harmful case that defendants could cite. And so I suggest that we have a real serious problem on our hands. And the best way to get out is through a legislative option in which Congress would limit the scope of efficiency defenses so that a defendant could only suggest or point to benefits that offset the harms to the very party, to the same party that suffered the harm from the restraint in the first instance. Let me spend, just in the interest of time, let me go over to Ted's, and then I'll pass it over to Sandeep. Ted does a very good job explaining why he doesn't think the Amex exemption, or what I'm calling the Centurion exemption, applies to the case of NCAA. And he says that there are two attributes of a two-sided transactional platform that don't apply. And he convinces me of it. The first one, he talks about indirect network effects. He thinks that they're weak in this platform. And an indirect network effect, did you define that? Maybe I should define it. But it's this notion that as I bring up people, as I bring up customers on one side of the platform, that's gonna increase the demand from the customers on the other side of the platform, and there's kind of these spillovers that go back and forth. A lot of platforms engage in this, but Ted argues in his piece that indirect network effects are weak in the NCAA case, and he also argues that the proportionality assumption is violated, and Ted interprets this as a one-to-one proportionality. I don't know if the Supreme Court in Amex actually defined it as such, but let me just make this point.
Yeah, but it's how the court also interpreted, or the lower court
right.
interpreted.
Right, but I just want to say, so I think what I fear is I don't want someone to think that because Ted has convinced himself, and this one court has, that a conservative judge who wanted to upend the enforcement of antitrust, where a platform is the defendant, could not see, this is what I'm worried about, is that a judge could see, if he or she wanted to, how indirect network effects would apply, or would interpret proportionality not to be one for one, but instead of, just as an economist might, just proportional, some ratio. It doesn't have to be one-to-one, but that the two sides kind of move in proportion. If that's the case, I fear that a court or a judge, if he or she were so inclined, could really use Amex to do a lot of damage in antitrust cases. I have another point on the seesaw principle, but maybe for the interest of time, we'll just pass it back, and if I get the mic again, we'll do it again. But thanks for having me.
So I greatly enjoyed all four of these papers, and I think the through line is that they show that antitrust unavoidably decides who wields power and, thank you, who doesn't wield power, either by blessing certain forms of legal entitlements and their exercise, so allowing firms to do certain things through their corporate charter and through their exercise of property rights, and then also condemning the use of certain concerted activities and certain contracts. So I'll start by talking about Sanjukta's paper, and I find this paper and her scholarship in general to be radical, not in the sense of bomb throwing, but radical in the sense of getting to the root of the matter. I think her writing exposes the shallowness of contemporary antitrust thinking, and for those of us maybe nostalgic for the post-war era, also shows the intellectual weaknesses of pre-Chicago antitrust. Her scholarship has shown that antitrust has never been an absolute order to compete. There are important qualifications and caveats to the injunction that market participants must vigorously compete against each other. And for me, her writing has exposed the limits of invoking competition, competitive process, and collusion. I think all three terms hide important ideological and normative judgments, and it's better that we honestly debate the normative and ideological judgments instead of trying to appeal to purportedly neutral concepts. So as a preliminary matter, certain forms of competition are simply off the table. And the examples I'm going to describe are actually rooted in historical or recent antitrust cases, not necessarily involving the company I name, but they have been the basis for successful antitrust claims. So I'm going to talk about the cola market. So for instance, Coca-Cola can't gain market share by claiming RC Cola has arsenic, blowing up RC's factory, or using its category captain position at supermarkets to throw RC bottles and cans into the trash. So the last example has actually been on my mind lately because there's an early case from the 2000s called Conwood versus US Tobacco, which actually involved the leading maker of smokeless tobacco sending its category captains to convenience stores and grocery stores and ordering them to literally throw the rivals' smokeless tobacco cans in the trash and hiding this fact from the store manager. It's a fun case if you want to get a sense of how tortious conduct can give rise to antitrust liability. So as a preliminary matter, there's a distinction between fair and unfair competition. We have made normative judgments. And furthermore, antitrust allows certain forms of cooperation and prescribes others. Indeed, as I said earlier, antitrust has never been an injunction to just compete at all costs. As Sanjukta has written, it most importantly allows coordinated economic activity to happen through the firm, and the firm at present especially subordinates the interests of workers, communities, and suppliers to the interests of the firm's financial constituents. And furthermore, this is probably a familiar example to most or all of you. So collusion today is the supreme evil of antitrust. So if two firms are rivals, they cannot fix prices or allocate markets. Typically, if they are found to have done this activity, the DOJ will come knocking and likely seek indictments against its executives and impose significant criminal penalties. But of course, direct rivals have a major escape. They can simply avoid competition by merging. And for the most part, antitrust law today allows coordination through mergers. And similarly, and albeit in more qualified ways, workers who are classified as employees can form unions under the labor exemption embodied in the Clayton and Norris LaGuardia Acts, and farmers can build cooperatives under the Capper-Volstead Act. So I think going forward, Sanjukta's writing shows that we should be honest about who gets to do what instead of hiding behind language like collusion. Oftentimes when I'm discussing antitrust concepts and doctrine, even with fellow progressive antitrusters, invoking the word collusion or suggesting something along the lines of collusion will cause an immediate recoil. I would say people in antitrust react to collusion in the same way ordinary people react to the term adultery, with sheer disgust. And in a sense, like the thinking stops there. Once collusion is invoked, it's just like, should the executive go to prison for 5 or 10 years? Should the company should the company face a $50 or $100 million fine? It's almost like, all right, whatever you're describing is categorically bad. Let's just figure out how hard to whack them with various legal remedies. So going forward, we should just be honest. Collusion is really not the supreme evil of antitrust. There are actually many forms of collusion that fall into what many of us would think of as socially beneficial cooperation. Let's have an honest debate about where to draw the line. Turning to Brian's paper, I find Brian's paper fascinating because it connects two strands of literature that have largely gone unconnected and really bring together two worlds that don't ordinarily communicate. So Brian shows that franchising is fundamentally an antitrust issue. So many of you are probably familiar with the work of David Weil. He wrote the book Fissured Workplace, which talks about the rise of franchising, the use of independent contractors. He does a great job showing how some of the leading firms, and also not leading firms in the economy, have outsourced core functions of their business to third parties. My one frustration with Weil's book is he's relatively silent on the connection between the law and the rise of the fissured workplace. He doesn't really talk about what happened over the past 40 years that encouraged businesses to adopt this very different business model. And the difference is especially acute between the fissured workplace and the post-war economy, where a company like GM literally employed everybody under its roof. And Brian shows that the rise of the fissured workplace is closely tied to changes in vertical restraint law. And Brian does a great job explaining how vertical restraints went from being suspicious to per se legal to rule of reason, which in practice means most vertical restraints today are legal, de facto illegal, even though on paper they can be challenged under the rule of reason. And I think going forward, as we talk about and think about new approaches to vertical mergers and vertical integration, it's important to keep in mind that property-like arrangements can be achieved through contract. So if we call for strengthened vertical merger rules, as my organization, the Open Markets Institute, a number of allies have called for, it's important not to keep open this alternative option of exercising similar control through contract. And I think Brian's work does a good job of showing how contract can be a tool for control and domination. The prevailing thinking on contract, especially in the law and economics world, is contract's really a way of efficiently allocating risk across different parties. It's not really seen as a form of control and domination. And this is a good illustration of how law and economics has really erased power in our political economy. And there's a fascinating article in the New York Times from about 3 or 4 months ago about Subway franchising. So Subway sells itself as a relatively attractive way for working class people, especially recent immigrants, to acquire some material comfort and some autonomy. And the article goes into great detail about how Subway presents its franchisors with a 600-page franchise agreement, which hardly any franchisee reads. They're simply presented the franchising option as a pathway to the middle class or even upper middle class. And it turns out that the Subway franchising agreement has something called a unilateral modification clause, which allows the Subway franchisor to change the terms of the franchise agreement even after the franchisee has spent hundreds of thousands of dollars and taken on the equivalent of a mortgage to start a franchisee. So it really exemplifies private power in action, and it has some really appalling stories of abusive franchisor managers taking revenge on franchisees they simply didn't like and citing them for nominally technical violations and even forcing certain franchisees to forfeit their valuable franchisee, one that they poured significant money into. And last but not least, I think Brian's paper does a great job tying politics and power to ideological changes. So if you ever listen to the Chicago School's own history, they present themselves as achieving an empirical victory over the post-war antitrust regime, which was defined by the structure, conduct, performance model, as well as other theories that were backed in large measure by empirical research. And they present this idea, and there was this conference called the Early House Conference in the early 70s, and the Chicago School argues that this was when they achieved their decisive intellectual victory, and afterward, everything that came was inevitable. And Brian shows that no, this actually was a political victory and really a matter of powerful interests marshaling academic theories to expand their prerogatives. In this case, powerful franchisors and their trade associations using their power in Congress, the FTC, and the courts to remake vertical restraints law to expand their discretion and power. So I told Hal that I wouldn't actually talk about Ted's paper, but I'll briefly mention it because my colleagues at OMI and I are currently working on a brief in the Alston versus NCAA case that Ted talks about. And I'll just keep this brief. I want to open up the broader conversation.
Proof that cartels are inherently unstable.
Exactly.
Defecting. Go ahead.
I encroached on Hal's market. So Ted's paper gave me hope and then immediately dashed those hopes. So Ted's paper persuaded me of something that's been on my mind for a while. I think the fallout from the Amex decision of 2018 may be oversold. I think it was a lamentable decision. I think the decision really locks in some of the most exploitative, abusive conduct that defines the credit card market and credit card industry today. But I think Ted shows that the collateral damage may be relatively modest. To his credit, I think Justice Thomas's opinion included some important limiting language. So defendants won't just be able to blindly claim that they are a two-sided market and obtain special treatment. I think the opinion shows that defendants will likely have to show that their markets are defined by simultaneity and a one-to-one relationship between the two sides of the market. Unless they can show that, they likely won't be able to get into the special Amex land. Of course, I think defendants will invoke Amex cynically and rather shamelessly, but I think the NCAA litigation shows that judges will, and I hope will continue to be able to see through that argument. So that's the hope Ted's paper gave me. Unfortunately, his paper immediately dashed those hopes by showing that a lot of the same arguments may be made under the framework of the rule of reason. So this is a problem that actually transcends Amex and predates Amex. And the district court in the NCAA case did, in fact, balance harms to the workers, the sellers of athletic services, against the benefits to another group, viewers of NCAA sports. So I think we may ultimately win the battle in Amex, but lose the war over the rule of reason. I think the rule of reason, I think this balancing issue also shows that even when we're not necessarily debating consumer welfare, we may be engaging a proxy war on consumer welfare.
Thank you for your comments. I'd like to turn it back to the panel if you each want to take just maybe 2 minutes to respond to the discussants, and then we'll open up the floor to questions.
Sure, and to Sandeep's point, this might be the first time I've ever been accused of being an optimist. I do think both Sandeep and Hal's concerns are very much warranted. I was certainly very much heartened by the way the lower court interpreted Ohio versus Amex, and for two reasons. Number one, one of the main concerns was that by simply being able to say, oh, this is a two-sided platform, the defendants would be able to shift the entire analytical burden onto the plaintiffs, and given the fact that defendants really, in many cases, hold all the cards, that is, hold all the data, it would really impose a Sisyphean burden on the plaintiffs. So I took some heart that was not the case, that the court did say, look, if you're going to make the multi-sided platform argument, you are going to have to use analytical rigor. But then, on the other hand, the fact that this argument was able to survive and sort of surreptitiously move to step 2 of the rule of reason, has given me a lot of concern that, but for the future, that they are right.
So I think we understand the impact of Amex because we're all discussing it here, and Hal raised it in the context of my paper, whether you can offset harms to labor by some argument that consumers benefit on the other end. And I think I'm the only litigator on this panel, and as a litigator, a Supreme Court case matters, and facts matter, and my reaction to Amex is, okay, how do we limit this? What is the limiting principle here? Because every market could be framed as a two-sided market. There's always an input and there's always an output. So what do we do to limit it to the facts that the Supreme Court considered? And I think that, for me, the worst part of Amex was the shifting of the burden of proof, which as a litigator matters a lot. And so I'd rather have it in the pro-competitive justification basket, but I think we're going to have to tie those justifications to the conduct that we're alleging is anti-competitive, and we're going to work hard to limit that case. Just want to make one brief comment. You mentioned the Conwood case, Sandeep. So there was a case called Apex Hosiery v. Leader back in 1945 where it starts out by describing this massive charge on a factory by a bunch of workers, and the Supreme Court decided not everything is an antitrust problem here. Just one last comment on legislative intent. There's been a lot of comments about going back to the legislative intent. I quoted something from the legislative history. I think it's really important to consider legislative history against the backdrop of all of the learning, and especially the economic thinking and the rigor of evidence, how to present evidence that we've learned a lot in the last 100 years. I see antitrust as evolving. We should remember the past, but also take advantage of what we've learned in the interim.
Yeah, I mean, I guess the production function is a two-sided market. Now all firms are just two-sided platforms. I mean, it's very, I'm very confused by the whole notion. But I just want to or echo or amplify what Sandeep said about this weird notion of contracts and property rights and how they're supposed to be separate, but they're kind of the same. They can accomplish the same thing. To quote, so we're talking about Chicago, Coase, said, a property is not a thing. It's rights to do things. That's what a property right is. And the property is supposed to be defined as the residual control right after everything that's not in the contract is there. But as we've seen with franchise contracts, you have business people who have legal title to assets who actually don't have residual control rights. So that another business can tell them, hey, you're going to have to take that asset and invest $1 million more in it of your own money. So I think maybe there's a law and economics paper in there somewhere about property and property rights and how they just don't match what what lawyers think property is, what economists think. I think they're not the same thing, and what that gap is, I think, is an interesting question, and that might be some work done there.
Okay, so a couple of quick comments. I realized that I actually didn't explain this very well because I think I said something like Uber's not even a firm, but of course it is a firm, but what I meant to say was that when it's setting prices for ride services, right? And that activity is outside its own firm boundary. So in that sense, even what I call the firm exemption doesn't protect what it does, right? So it's this like additional frontier of top-down coordination. Okay, I just want to explain that. And then the other point was that, Sandeep was talking about firm-based coordination, and something he said reminded me that I should clarify that it's not just that we sort of have this firm exemption, and so because of the way that sort of corporations are currently set up, that ends up sort of privileging investor concern, privileging investor concerns and interests, but rather that antitrust itself supplies its own criteria for deciding what a business entity is. So in fact, to make it very clear, it doesn't take corporate law, what corporate law or any other sort of state business entity law gives as dispositive for what a firm is, right? So that's why I think that some producer, like worker co-ops, wouldn't actually qualify, especially in ways that would be feasible for them to initially organize. I think that's a real problem. Okay, and then finally on fair competition, and so I think that this, at the end of Sandeep's comments, one might ask, well, what should we do instead, right? Well, I think we have to come up first with sort of meta criteria as an alternative to the current criteria we have for allocating coordination rights. And I would suggest briefly that they should be twofold. One, that we should return to the original legislative purpose, and we should maybe clarify what they could have been even clearer about, and we should aim to disperse rather than concentrate coordination rights. And that is a bit clearer, I think, than just saying disperse rather than concentrate power, right? So once we've sort of reconceptualized what antitrust is, and then that's not enough. I think secondly, also we need rules of fair competition, which Sandeep emphasized we already have, right, implicitly, but we need to acknowledge this as part of antitrust. We're not just like promoting competition as such. So we should develop both of those and embrace them, and just ending that. So the example you gave about throwing the cola bottles reminded me of the cash register trust, and not in the case, but in the business history of the cash register trust. So one of the things that the American Cash Register Company did was, way back when, was that their salespeople would go to stores that had rival cash registers and surreptitiously pour salt in the mechanism. So not fair competition.
Mark's going to be taking questions, so raise your hand if you'd like to.
So hi, so I take it that the panel is concerned about increases in firm power that harm workers. I wonder about the converse, though, which is the possibility of increases in firm power that may actually help workers. And I'm pretty sure that's an actual set of things in the world, because there are a number of cases that are, I think, questionable cases on antitrust grounds of mergers where unions actually strongly support the merger. So let's take the example of AT&T T-Mobile, where the 3 million worker-strong telecommunications union strongly supported the deal on the grounds that T-Mobile had a terrible culture for workers, was anti-union, and AT&T was much better, and that by merging those two firms, AT&T's culture was going to permeate T-Mobile's, and that was going to raise wages and working conditions for working people. And so same thing, American Airlines, US Air, the pilots union supports the deal. So there are lots and lots of deals that we now say should not have been allowed or were not allowed on antitrust grounds where there's actually union support for the deal. And my question for the panel is, so in those cases, should we take into account union support? Should that be an affirmative factor for allowing a merger that looks otherwise anti-competitive to go forward? And if we do, then do we balance the interest of workers against the interest of consumers?
You don't have to. Okay.
Yeah, I think there was and I think a lot of unions also have a sort of nostalgia for the golden age era was when the union density was in those monopolized firms. And I think that, not talking about the specific, I don't know the specific details about these cases, but I think partly that's misplaced because it's monopoly profits that are oligopoly profits that like GM, the big three get, that some of which are shared with workers. But again, with fishing, immediately they start shedding, they pull in the boundaries of the firm, and most auto workers don't work for the big three. Most of them work for parts suppliers, which are very low margin, low wage sort of industries. So I think there's counteracting effects. A monopoly can benefit workers if they share in the monopoly rents, but in this day and age with 10% or 7% private union density, that's just not happening. I'm not sure they're as intentioned as they used to be.
Can I? Elinor, go.
I'll just say one thing about that. So I don't think that an enforcement agency looking at a merger would validate a merger because of union support or invalidate a merger because of union support. I think our concerns are much broader than that. Unions represent one constituency. It's not the only constituency that we have to look at. So I'll leave it at that.
Sorry.
Oh, no, go ahead.
I think I want to be consistent with my embrace of no offsets. So in AT&T Time Warner, it wasn't the case. The judge was not convinced by the economist's model that there'd be a price effect. But assume that the opposites, assume that there was concrete evidence that the merger was going to raise prices to the detriment of consumers. I don't think the fact that a statement by the union that they embraced it should be used in any way, shape, or form to offset a clear harm from the merger to a distinct set of customers.
Okay, but that assumes that consumers are the primary group
No.
that should be considered in mergers.
No, it doesn't. Let me tell you what it assumes. What it says is we have under enforcement of antitrust now, and if you can show me either how a merger harms a party or a restraint harms a party, I don't want to hear any justification or offset that concerns a distinct party. I don't want to ask judges to engage in that balancing.
But
just show me, sorry, just let me finish. Just show me the harm and connect it to the restraint in question. And I will consider efficiencies, but I will only consider efficiencies that make the harmed party better off, period, end of story, all right?
I'm going to try to answer Professor Crane's question as honestly as I can, which is that I personally, I'm not speaking for anyone else, think that should be a complicated question. I don't think union support, obviously, should be dispositive on its own, but I think to the extent that effective collective bargaining rights are one form of dispersing coordination rights among working people, I think that should be considered. I think it's complicated because I think that should really be a labor law problem. I think everyone should have collective bargaining rights, and then we shouldn't have antitrust enforcers shouldn't have to be worrying about this, but I would honestly say that I think that's a tough question, or can be a tough question.
So I almost always agree with Sanjukta on these issues, but I'm going to differ with her slightly here. So I believe in a rules-based approach to merger policy. I love Philadelphia National Bank. I think the 1968 merger guidelines are a good template that we should revive. And I don't think the fact that a labor union came out in support of a particular merger should play into the analysis. Instead, I think going forward, we need stronger antitrust rules, and as Sanjukta said, also make it much easier for all workers to unionize instead of hoping that labor unions can maybe get some benefits from harmful consolidations. So I think the Obama administration was absolutely right to stop AT&T, AT&T 2Mobile, and try unsuccessfully to stop American US Airways.
Sorry, let's go to the next question. We'll talk about this afterwards. But I heard that as Sandeep agreeing with me.
Yes, I agree with you.
Thanks.
It's not the first time.
Hello, it's me again. Here's the question I have. I'm not quite sure what makes this different than what happens in, say, regulated industry mergers. So for example, if I have an electric utility that's merging, what typically happens is customers, competitors intervene at FERC, for example, to extract their pound of flesh from the merging parties. And as they extract their pound of flesh, they withdraw their intervention. And so we actually, when we do those kind of mergers at the Antitrust Division, don't care anything about that because it seems very self-serving, it's probably very short-sighted, and when we talk about unions doing roughly the same thing in terms of endorsing a particular merger or not, well, the history of unions is one of short-sightedness to begin with. So I'm not quite sure I'm convinced that that endorsement would be helpful in any antitrust analysis.
I'll take a crack at that. I think you answered your questions that we need sectoral collective bargaining. So the incentive structure of collective bargaining in the United States, it's not even firm level, it's establishment level. So that puts enormous pressure on unions to back their companies. They should be fighting their companies, but because you represent one company out of 20 in an industry, it's a very powerful incentive to grow your membership or to get more power in the political. It also has a political economy effect. So the stronger the unions are, the more they can lobby the government for more pro-worker policy. But the fact that unions do make self-serving arguments and short-sighted arguments in these regulatory arena, sure they do. But I think that the problem with that is that it's a structural issue. We don't have sector-wide sectoral bargaining, general unions in the country.
One more question, anybody?
Christian Bergqvist, University of Copenhagen. Contrary to most European, I take no pleasure coming to US and telling you are wrong. Nevertheless, I will do it because I believe that what the Supreme Court tried to say in the Amex case was that there's a difference between a two-sided transaction platform in which a service cannot exist without the other service and just two-sided markets. The two-sided transaction platform, there's only one market, just a two-sided market. It depends on the circumstances. However, that is not my question. My question relates to something else. Listening to the discussion, I noticed none of you had touched upon the difference between employee and self-employee, and the fact that the digital economy and transaction platform to an ever higher level of degree utilize a model of self-employment. Because that is a huge matter in Europe, because employees are allowed to group together in unions and demand higher salaries. Self-employed are not allowed to do that. My question is, the fact that you have not touched upon it, is that because that is not a concern in the US, or it's more a question that you didn't have time or opportunity to discuss it?
Let's take it.
I did talk about that a little bit. I mean, I talked about the oil dealers, the franchisees. I mean, so it's not tech, but it's the same thing. These are independent contractors. There's reasons to use independent contractors when it's a genuine independent contracting relationship. But in these cases, the firms, I think, as I think you're alluding to, take advantage of the lack of legal rights and the lack of paying the benefit costs and all of that. I think that Sanjukta and Sandeep have some thoughts about alternative arrangements, that's the worst phrase to use, but ways for those workers to also have collective action. But yeah, I mean, I was trying to make, and I apologize if I wasn't clear enough, but that vertical restraints is sort of a substitute for an employment relationship. I meant to say, in fact, I would say that what franchisors and their allies in the 60s were able to accomplish enables things like platform-based gig economy. They allow firms, the relaxation of restrictions on vertical restraints is what allows these platform companies to set prices across the boundaries of the firm and to set wages. I had a slide that I didn't show, but Uber had an ad for an economist last job market, when I was in the job market, where they said in very purple economies that we want economists to help us set prices and set wages. But we don't want to call it prices and we don't want to call it wages. And that's so I think that's, I think that the self-employment thing is very much a part of all of this. And digital firms do it now, but it's been, gas station dealers, that's the most old economy thing you can imagine. And this happened to them in the 30s.
We're going to have to give Dr. Callaci the last word today. We've come right up against our time constraint. And I want to thank everyone who attended. I hope that we'll see you tomorrow morning for breakfast at 8 a.m. And one more panel on antitrust and big tech. Participants, panelists, and discussants, we're going to convene in the general over there area to wrap up the evening together. Everyone else, see you tomorrow. Thanks so much.